morning. My name is Parole Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Brian Perry, inmate number 373781. Today is Tuesday, April 1st, 2025. This hearing is being conducted via video at the Board of Pardons and Parole Central Office and Robinson Correctional Institution. Please state your full name and DOC inmate number for the record.
Brian Perry, 373781.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is your attorney.
Good morning, Public Defender Robert Famigletti of the Parole Revocation Unit. Hello, sir.
As well as your parole officer.
Hi, Parole Officer Gerard.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probable than not the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony at today's hearing will be taken under oath. Mr. Perry and P.O. Gerard, please raise your right hands. Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Thank you. P.O. Gerard?
Yes, I do.
Thank you. First, I will read you your rights, and then we will review the parole violation charges that the state your parole officer is bringing against you. Then I will review and identify exhibits filed for the record. Both the state as well as your attorney will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, the state as well as your attorney will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, ma'am.
Thank you. You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes, ma'am.
We now will review the charges that the state your parole officer is bringing against you and the information underlying each charge. Starting with charge 1 GPS, P.O. Gerard.
Yes, charge 1 GPS. On 1/6/25, you signed out of Stein Halfway House at 4:25 p.m. with an approved return time of 11:45 p.m. Your pass granted you to travel to your place of employment, Chick-fil-A in West Hartford at 509 New Park Ave. Upon staff conducting an employment verification check and per your GPS monitoring device, you did not report to work. This is in violation of your GPS agreement that states, I will follow all established curfew, work, and program schedules and must obtain prior permission from a parole officer prior to changing any established schedules. On 1/7/25, you signed out of Stein Halfway House at 3:57 p.m. with an approved return time of 11:45 p.m. Your pass was granted for you to travel to your place of employment, Chick-fil-A in West Hartford at 509 New Park Ave. Upon staff conducting an employment verification check and per your GPS monitoring device, you did not report to work. On 1/9/25, you walked out of Stein Halfway House without authorization. You walked out the door at 1:01 p.m. and did not return back to Stein Halfway House until 3:28 p.m. This is in violation of your GPS agreement that states, I will follow all established curfew, work, and program schedules and must obtain permission from a parole officer prior to changing any established schedules. On 12/11/24 at 9:57 p.m., you exited the front door of Watkinson Halfway House. A staff member followed you to inquire where you were going. You responded, y'all called the effing cops, right? And continued out the gate and off the property. You did not return to Watkinson Halfway House. This is in violation of your statement of understanding and agreement agreement conditions of parole, specifically in the event I am placed in a halfway house, I agree to go directly to and reside in the facility designated by Parole and Community Services Division until released by the Parole and Community Services Division. I will abide by the written rules of the facility. I will not leave the physical confines of the facility or the property thereof, except for traveling to and from work or as authorized by facility or Parole and Community Service Division rules. Charge number 3, halfway house placement. On 1/9, you walked out of Stein halfway house without authorization. You walked out at 1:01 p.m. and came back to Stein at 3:28 p.m. You had communication with your assigned PO during this period, and you were directed to go back to Stein halfway house. You did not follow that direction. You were unaccountable in the community for 2 hours and 27 minutes. This is in violation of your statement of understanding and agreement conditions of parole. Specifically, in the event I am placed in a halfway house, I agree to go directly to and reside in the facility designated by the Parole and Community Services Division until released by the Parole and Community Services Division. I agree to abide by the written rules of the facility. I will not leave the physical confines or the facility or the property thereof, except for traveling to and from work or as authorized by facility or Parole and Community Service Division rules.
The state's exhibits were marked and identified at the preliminary hearing held on January 27, 2025. The state found an addendum to Exhibit AA, which states on February 13, 2025, Mr. Perry was served with a warrant by Connecticut State Police at Robinson Correctional Institution. Mr. Perry was charged with assault third. Counsel, did you receive the notice of parole violation report, and the other documents that were just marked for identification purposes?
Yes, I did, and there should have been an additional addendum filed because that assault third charge was nollied on March 14th.
Thank you. Theodore, did you file an additional addendum? Because I did not receive that. Did you file one?
I did, yes. I think it was just approved yesterday. I believe the addendum was approved yesterday, and my addendum was just stating that, let me see. The addendum says on 3/17, this PO was informed that subject appeared in GA 14 in court GA 14, and the case for his assault third charge was disposed of and nollied.
Okay, thank you.
So, yeah.
Defense has also filed Exhibit 1, parole accomplishments and future plans for parole reinstatement, as well as Defense Exhibit number 2, employment letter from Tyquan Johnson. Today we have no witnesses. At this time, the state will have an opportunity to present evidence to speak to any of the evidence submitted. Pio Gerard?
Well, per the parole violation report that we submitted, we have with his GPS coordinates, we have that he was in fact unaccountable in the community on those 3 occasions that I mentioned where he signed out of the halfway house for work but never reported there. Also, as far as residence goes on with the incident that happened on December 11th, he did in fact walk out and leave the halfway house, and rather than violating him, parole attempted to work with him and place him in a new halfway house, which then ended up being under my supervision. So that's all I have.
Thank you. It is now the defense opportunity to present evidence to speak to any of the evidence submitted. Counsel?
Yes, as to the preponderance standard, on the January 6th and January 7th dates, he was gone approximately 7 hours, each of those dates. And one of the things that the parole officer read is that you're not allowed to do that without parole permission or without halfway house staff permission. And my client actually had permission from Alicia Brown of the halfway house. What he was doing during that time was he was attempting to acquire a dog for her And so that's why he had strayed those 2 days in a row to do that. And so our claim is that he was permitted by Alicia Brown to do that. As to charge 2, him being gone for 17 hours on 12/11, he also had permission to do that because that was the date of the incident that the arrest warrant subsequently that was nollied, that subsequently was filed served on him in February. He began leaving, and the parole and one of the halfway house staff asked him, where are you going? What's going on? He goes, I want to just cool down. This just happened. Did you call the police? So they told him it was okay for him to leave the halfway house to cool down for a cool down period to make sure nothing further happened. He did eventually return. And so for those reasons, for charge 1 and charge 2, we believe that the preponderance standard isn't met because he was given permission. Thank you.
Counsel, I just want to clarify, you said that he received permission from Alicia Brown to go obtain a dog?
Yeah. To
obtain a dog.
To go look for a dog, correct.
At the halfway house?
No,
She's a staff
personally.
Oh. She's a staff at the halfway house?
Yes.
Thank you.
You're
Gerard?
Yeah, that is, as far as I'm concerned, completely false. This is my first time ever hearing anything like that. Typically whatever is on the pass, that's where he's able to go. Whatever is on his pass, whatever it is that he's been given permission for, that's where he's able to go. So as far as I'm concerned, as far as I know, that's completely false regarding Ms. Brown, who works at the front desk. That's her role. She works at the front desk. And as far as the incident that happened on December 11th, halfway house staff would never allow someone to just walk off the property overnight. I mean, walk off the property in general. That could be broad daylight, but and they wouldn't allow that. That's just not something that's allowed.
Just briefly in response, we completely agree. We completely agree that that's not allowed, but he is allowed with permission of the halfway house. He was only relying on what they said to him. I'm sure it comes as a surprise to the officer. It came as a surprise to me, but we're just claiming that is why he felt it was okay for him to leave. Thank you. And also, that is also why he felt it was okay for him to go and divert from the pass to get the dog. Thank you.
Gerard, anything further?
I mean, the only thing I would ask is there any proof of either of those accusations that at 2 separate halfway houses, 2 separate staff members allowed him to be unaccountable in the community?
Just my client's word. And I guess there's just as much proof that he didn't have permission. We're just going by what we're hearing from the halfway house staff. So I guess, and they're not available for cross-examination. They're not available as witnesses. So, I'm just going by what my client has told me. I'm just going that I don't believe that because he had permission, it should be a basis of his violation. That's all. Thank you.
Thank you. Gerard?
Yes, the only thing I could say to that, and I respect everything that you're saying, the only thing I could say to that is that the offender signed misconducts for all of these things, his signature on it, and never once brought any of this to our attention up until this morning.
Thank you.
So,
Counsel?
Yep.
I've got nothing further as to the preponderance standard.
Thank you very much. I'm just going to take a moment before I announce my findings. Regarding charge 1 GPS, a no finding was made on part 3 at the preliminary hearing held on January 27th, 2025, and will not be considered as today's revocation hearing. I make a finding on the rest of the parts listed in this charge based on state's exhibits D, M, O, P, Q, R, U, and AA. Regarding charge 2, halfway house placement, I make a finding based on state's exhibits D, E, I, J, L, S, W, and AA. That concludes the fact-finding portion of this hearing. Before I make my recommendation, your attorney as well as the state will have an opportunity to speak to your background and history. P.O. Gerard, would you like to make a statement regarding Mr. Perry's background and history?
I would just say that Mr. Perry was under my supervision for a little bit over a month. And during that time, I made every attempt that I could to work with him, talk with him, and get, kind of everything figured out. Like I said, I took over really just at the tail end of his supervision, but based on all the evidence and exhibits that are listed in here, he has shown a pattern of aggression and disrespect toward anyone placed in the position to supervise him. Whether if it was a parole officer, a parole supervisor, anyone. And I know I listed some of the exhibits here of some of the interactions that he had with some of the parole supervisors, with him basically cursing them out and saying all sorts of stuff. And even with me, who I felt like I had a relatively, good rapport with Mr. Perry over the 4 to 5 months that I was supervising him, but during his remand back to custody, he was so aggressive that the other POs said, you know what, Gerard, just we'll deal with him because he clearly has some rage going on and it's directed toward you. And so not only did they do transport bringing him to the facility, but they also took over with serving him as well, because just because we didn't want to trigger him anymore in any sort of way. And for me, it did feel like it kind of came out of nowhere, obviously, with the circumstances of his being remanded back into custody. That usually isn't a good day for anyone, we're in his position, but his aggression and rage, I think kind of throughout the remand, and then his aggression throughout his supervision, just showed a clear pattern of negativity. I think that's all I have. Thank you.
Thank you. Counsel?
Yeah, that's completely unsubstantiated. We have 2 charges here. First, he was out on parole for 3 months, not supervised by this parole officer, with absolutely no problems. None. From September 19th to December 11th, which is the date that he left, and he says he had permission to leave. So we're talking about leaving and not going where he's supposed to go in his past. That's what this violation is about. It's not about his attitude. It's not about any there's no alleged aggression here in this violation. There's no alleged rage here in this violation. This is all materialized 5 seconds ago. It's no part of this violation. None of the exhibits should go to any rage or anything of that effect, because it's not an element of a GPS violation, and it's not an element of the halfway house placement for being gone 2 hours and 27 minutes and being gone 17 hours after the incident, which was not late. There's absolutely no elements, nor is it relevant to the testimony today that someone thinks he has an aggression or rage problem. That's prejudicial. That's an attempt to say that my client was in any way, shape, or form a bad parolee. He wasn't. The only basis here, and these are very minor violations. He's been on parole for 4 months here, and January 6th, 7th, and 9th, he's gone. One of those, there's no finding for the 9th. So the 6th and the 7th, he's gone while he's supposed to be at Chick-fil-A. Okay, didn't commit any new crimes. He wasn't violent. He wasn't aggressive. He was trying to find a dog, if you believe our aspect of it. Otherwise, this is not like he was somewhere else committing a crime or being aggressive, like we're to believe that my client is aggressive. He's a productive member of society. We have a letter, Exhibit 2, from a coworker who helps operate Latimer Concrete. He's been a concrete mason for the company for the last several years. Upon his release, the Department of Parole in Hartford requested information for the company of vehicles. The information was provided to them, but Mr. Perry was still not given permission to work with the company again for no apparent reason. When he's released, he will still have a position with Latimer Concrete. He's 33 years of age. He has 4 children. He receives support from his mother, father, 6 sisters, his significant other who suffers from multiple sclerosis, his children's mother, and his boss, Anya Latimer. My client enrolled at Academy de Capelli. However, he was unable to begin because he was remanded for these minor violations. He's had a great job in the past several years for Latimer Concrete Forming in Hartford. He did work as a full-time breader at Chick-fil-A while he was in Steinhouse. He's worked in the past at FHI, FedEx. He was hired at Amazon, and he was a cook at a local hospital. He has an excellent work history. He was in a weekly anger management group at community renewal team in the past. He took reasoning and rehabilitation program, participated there twice weekly at CPA. He completed a 5-hour anger management course online. It was a one-on-one course. He was participating back in 2022 in individual psychotherapy, including anger management at Wheeler Clinic. He has in the past, through his football prowess, as he plays for 2 semi-pro professional football teams, one in the summer and one in the fall. Those teams are the Connecticut Lightning in the summer since 2020 and New England Bulldogs in the spring. He helps by pulling at-risk youth off the streets and helping them become involved in football. He wishes to be sponsored by his significant other, Angelina D'Alessandro. He wishes to enter a barbering program at Academy di Capelli, as he had been accepted in the past, but unfortunately was remanded. He can return full-time to Latimer Concrete. Over the past 3 years, I've seen a lot of serious violations. I see a lot of violations for violent reasons, a lot of violations for multiple reasons. Here we have 2 occasions that he was gone for 7 hours. And then another occasion after the Nolly case, after that incident occurred, he cooled down, came back to the halfway house. I'd ask that you release him the soonest possible date. I don't believe any of these violations are sufficiently serious to hold him any further. He's been held since January 10th. Thank you for your time and consideration.
Thank you. P.O. Gerard, anything further?
Nope.
Thank you. I'm going to take a moment before I announce my recommendations. Okay, Mr. Perry, I have that you have been in the community, or you were discharged to special parole starting in May 2020. Since May 2020, this is your third parole violation. Prior to this violation, you had 2 criminal violations that resulted in new convictions. During this violation, you were in the community for about 3.5 months. And within that time frame, you received a number of PCS conducts and residential discipline reports for engaging in verbal altercations, leaving the halfway house without permission, and being unaccountable in the community. Taking into account all of what was said here today, including the new addendum, acknowledging that there was a nollie for an assault third, as well as your history and all the behaviors occurred during this during this violation, I recommend revoke and reparole on January 12th, 2026, which is an approximate 1-year sanction with the following conditions: no consumption of alcohol, anger management, no contact with co-defendant PB, no contact with victim MW, a general no contact with NA, mental health treatment, and no operation of a motor vehicle without the express permission of your parole officer. My findings and recommendations will be forwarded to the board, and you will receive the official written decision from the board. And your board review is scheduled on April 10th, 2025. So next Thursday, the board's going to say, look at your case. They can lower my recommended sanction, they can exceed my recommended sanction, or they can adopt my recommended sanction. Being that you're on supervision until May 2026, they have up until then, they could exceed it until your end of sentence. But again, on the 10th, the board's going to make their final decision, and you'll receive written notice of what their decision is. Okay, Mr. Perry?
So, Mr. Perry, hopefully the board will shorten this. It's up to the board to make a final decision. They're going to meet on April 10th. Give our office a call on April 11th, and we'll let you know what the board decided. Okay, sir?
All right.
All right. Hang in there, okay? Take care.
Thank you. Good morning.
Hi, good morning. How are you?
Good, good. Who do we have there already?
I have all 3.
You have all 3, so we can start with Mr. Ray. Is he first? Yep, Mr. Ray.
And who would you like after?
We go right down the list, Baker and then
Right.
Bailey.
Okay, got you.
Thank you.
You're welcome. Right?
Yeah.
You can come on in. Sure.
Good morning, P.O. Dunn.
Good morning.
Precious.
Good morning.
Good morning, Mr. Ray.
Good morning. How are you?
My name is Parole Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Saeed Ray, inmate number 360932. Today is Tuesday, April 1st, 2025. This hearing is being conducted via video at the Board of Pardons and Parole Central Office in Osborne Correctional Institution. Please state your full name and DOC inmate number for the record.
My name is Saeed Wright. Inmate number is 360932.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is your attorney.
Good morning, Public Defender Robert Famigletti of the Parole Revocation Unit.
As well as your parole officer.
Good morning, Parole Officer Dunn, Hartford Parole Community Services.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probable than not the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony at today's hearing will be taken under oath. Mr. Wright and P.O. Dunn, please raise your right hands. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes.
Yes.
Thank you very much. First, I will read your rights. Then we will review the parole violation charge the state your parole officer is bringing against you. Then I will review and identify exhibits filed for the record. Your attorney, as well as the state, will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, your attorney, as well as the state, will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, ma'am.
Thank you. You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney at this hearing. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes, ma'am.
Thank you. We now will review the charges that the state your parole officer is bringing against you and the information underlying each charge. Starting with charge 1, obedience to the law, P.O. Dunn.
Charge 1, obedience to the law. On 8/29/24, Manchester police responded to a report at 9 Jennifer's Way, Manchester, where 2 males were reported as arguing verbally and that a gun may be involved. A video was recovered at the scene from a witness, and the recorded incident showed that you, Saeed Wright, number 360932, standing outside of your silver Infiniti Q50 sedan at the address and had been blocked in the driveway by another male in a Nissan Versa. You and the other male engaged in a verbal argument, during which time you were seen walking fast towards your vehicle to the front driver's side door. You open the door and are seen reaching down into the front driver's side seat/floorboard area to grab something. From the angle of the camera, what you grabbed from the vehicle cannot be seen. And then while standing by the driver's door, you make a hand motion that is consistent with the action of cocking a gun. From the officer's training and experience, the sound produced by your hand motion resembled the action of pulling back a hammer or slide of a firearm in an attempt to ready the firearm for firing. At that time, the video goes out of focus and yourself and the vehicles are no longer in frame. A victim can be heard in the video saying, quote, "Run, oh, go, 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 oh shit, he just cocked his gun back," end quote, before ending. For your behaviors and actions, a warrant for your arrest was applied for and signed off by a judge. You were subsequently arrested by Manchester Police and charged with CGS 53A 181 breach of peace, 2nd degree, and CGS 53A-62 threatening 2nd degree.
The state has filed the following exhibits. P.O. Dunn, starting with Exhibit A.
Remand to custody order. Exhibit B, signed parole conditions. Exhibit C, notice of parole violation. Exhibit D, parole violation report. Exhibit E, Manchester arrest warrant number 24000-45563. Exhibit F, decision information summary.
The state filed an addendum to Exhibit D, which states on March 11th, 2025, Mr. Wright pled guilty to breach of peace second and was sentenced to 30 days jail. The charge threatening second was not under docket ending in 3831. Counsel, did you receive the notice of parole violation report, and the other documents that were just marked for identification purposes?
Yes.
And defense has also filed Exhibit 1, parole accomplishments and future plans for parole reinstatement, and Exhibit 2, letter of support from Brianna Harris. Today, we have no witnesses. At this time, the state will have an opportunity to present evidence and speak to any of the evidence submitted. Appeal done?
No, I'd just like to point out that following the incident, as stated in the report, a couple days afterwards, Parole did call right into the office where he was detained. We then conducted a search of his residence and his vehicle. We did not find any contraband or weapons of any kind, and he was compliant during the course of the entire investigation, and then he was released without incident.
Thank you. Counsel?
As to the preponderance standard, the threatening was nollied. No weapons charge were ever lodged against my client, and he pled guilty to a breach of peace for the argument. So I have no comment as to the preponderance standard.
Thank you. Appeal done. Anything further?
No, ma'am.
Thank you. I'm going to take a moment before I announce my finding. On charge 1, obedience to the law, I make a finding based on Mr. Wright's conviction as well as state's exhibits B, D, and E. That concludes the fact-finding portion of this hearing. Before I make my recommendation, your attorney as well as the state will have an opportunity to speak to your background and history. Appeal done. Do you wish to make a statement regarding Mr. Wright's background and history at this time?
No, ma'am, I do not.
Thank you. Counsel?
Just briefly, I'd ask that you see this incident for what was proven, a breach of peace. A car drove in and admittedly, from all accounts, blocked my client into his driveway. The prosecutors in Manchester are very serious. I know them, all three of them personally. If they had any inclination that the gun was involved, they certainly would not have resolved this case with the breach of peace for 30 days. As the PREO said, my client was cooperative. They searched both his residence as well as the car. There was no firearm found. He was on parole for approximately 18 months. Before this remand, with absolutely no misconducts, no sanctions. This incident occurred last August. So there's been a passage of time without any additional incidents, with no misconducts whatsoever. He was remanded on January 17th, so he's been in jail now for some time. He has served the entire 30 days. The PO is leaving it up to the board. This is, I believe, his first violation. He was trying to get out of the driveway. He was blocked in his own driveway, and there was a mutual argument. Nonviolent, no injuries. My client is 37 years of age. He receives a significant support from his mother and grandmother and 5 siblings. He has 3 great friends that he gets support from, one being Brianna Harris, who wrote a letter on his behalf. He has 2 sons and is expecting a 3rd child to be born in June, and he would like to be out for the birth of that child. He completed 2 years at Eastern Connecticut State University, where he studied sociology and criminal law. He had worked in the past at Fresh Point, Connecticut, a Cisco affiliate, for 7 years. He was working at the time of his remand full-time at ADUSA. He successfully completed the Explore program at Wheeler Clinic. He was participating voluntarily every Monday in individual psychotherapy with Rebecca, located in Main Street in Hartford. He wishes to be placed in a halfway house in Hartford. He wishes to return to the sociology program at Eastern Connecticut, and he can return to his full-time position at ADUSA. I asked to note the letter from what appears to be Miss Harris, his good friend. My client, as I stated, I believe this is his first violation, 18 months with no problems whatsoever, no graduated interventions or sanctions. I don't believe a lengthy sanction is necessary or appropriate. I don't believe that this violation is so sufficiently serious enough to warrant further incarceration. Thank you for your time and consideration.
Thank you. You done anything further?
No, ma'am.
Thank you. I'm just going to take a moment before I announce my recommendation. Okay, Mr. Wright. I have that you were discharged to special parole in April 2023. And since then, this is your first parole violation. You were in the community for a little over 18 months. Within that time, there's been no reported misconducts or issues. However, you did receive this new conviction. However, this conviction has been served based off of the 30-day sentence. Taking all of that into account, I recommend revoke and re-parole on April 17th, 2025, which is an approximate 3-month sanction with the following conditions: domestic violence, anger management, no contact with victim AL, a journal contact with DH, and halfway house placement. My findings and recommendations will be forwarded to the board, and you will receive the official written decision from the board, and your board review is scheduled on April 10th, 2025. So your hearing with the board's going to take a look at your case next Thursday. And on that date, they can either agree with my 3-month sanction, or they can lessen that sanction, or they can exceed that sanction, being that you're on supervision until April 2029. If they do exceed that sanction of the 3-month recommendation, there's going to be another hearing to take place to justify additional confinement. Okay?
Yes, ma'am.
All right. Any questions?
No, ma'am.
Sir, just call our office on April 11th, the day after the hearing, and we'll let you know what happened. Okay, sir?
Yes.
Have a good day.
You too. Thank you.
Thank you.
Thank you.
Thank you, P.O. Dunn.
Thank you. Have a good day.
Thank you, Mr. Dunn. Thank you, Officer Dunn.
Have a good day, Saunders.
No.
Thank you. You too.
How you doing?
Hi, Mr. Baker.
How you doing?
Good. Give me a moment. I'm going to get your attorney in the room.
Say it again.
I'm going to get your attorney. Give me one moment.
You will.
Thank you. Good morning. My name is Parole Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Troy Baker, inmate number 266841. Today is Tuesday, April 1st, 2025. This hearing is being conducted via video of the Board of Pardons and Parole Central Office in Osborne Correctional Institution. Please state your full name and DOC inmate number for the record.
My name is Troy Colin Baker, and my number is 266-841.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is your attorney.
Good morning, Hannah Dean for the record on behalf of Mr. Baker.
How you doing?
This is a preliminary hearing which has 3 purposes under Connecticut law: to determine if there is probable cause to believe you committed an act that violated the conditions of your parole, to determine if the act is sufficiently serious to warrant the revocation of your parole, and to determine if you should be held in prison pending further proceedings. The state, not you, has the responsibility to show that there is probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding. Anything you say at this hearing can be used against you. This hearing is being recorded. The testimony at today's hearing will be taken under oath. Mr. Baker, please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes.
Thank you. First, I will read you your rights. Then we will review the parole violation charges of the state your parole officer is bringing against you. Then I will review and identify exhibits filed for the record. Your attorney will have an opportunity to address the issue of probable cause and the severity of the allegations. After the conclusion of this hearing, I will inform you of my findings, which will be based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
No, I'm all right.
Thank you. You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes, I do.
We now will review the charges that the state your parole officer is bringing against you and the information underlying each charge. Charge 1, obedience to the law. On March 13th, 2025, you were arrested for an outstanding warrant by Bridgeport Police Department. According to the arrest warrant issued by the court on or about January 7th, 2025, you were charged with violation of the Deadly Weapon Registry Requirements Annual Renewal. Charges stem from probable cause to believe that on July 22nd, 2024, you failed to complete your annual renewal. The states have filed the following exhibits. Exhibit A, remand to actual custody order. Exhibit B, State of Connecticut Conditions of Parole. Exhibit C, State of Connecticut Parole Violation Report. Exhibit D, State of Connecticut Notice of Parole Violation. Exhibit E, State of Connecticut Notice of Parolee Rights. Exhibit F, State of Connecticut Superior Court, Bridgeport Police Arrest Warrant ending in 635. Exhibit G, State of Connecticut Judicial Branch pending case detail. Defense has also filed Exhibit 1 of the court disposition regarding these charges. Counsel, did you receive the notice of parole violation report, and other documents that I just marked for identification purposes?
Yes, we have.
In regards to charge number 1, obedience to the law, on January 7th, 2025, a state of Connecticut Superior Court judge issued a warrant regarding Mr. Baker for violation of Deadly Weapon Registry requirements and established probable cause. Therefore, I cannot revisit this finding. However, it is now the defense opportunity to respond, to make a short statement, and testify with respect to the severity of the allegations.
Yes, so I would just notice, as you stated, my client did resolve the outstanding warrant on 3/27/25 with an unconditional discharge, no probation, no time to serve, no additional supervision. The allegations are that my client failed to register for the weapons registry back in July. However, the warrant did not actually come out until January of this year. I will note that during the time this alleged violation occurred, my client was on house arrest. He was living with his sponsor, who was his sister, and he was working, very long hours doing a program and was also on GPS monitoring. Neither himself or his PO knew about the violation, or else he would have handled it as soon as it came out. And he does not recall either ever receiving a letter during that time period, or he would have immediately taken the time to register to be in good standing. Right now, his biggest priority is getting out so that he can update his information and get into compliance with the registry. I would argue that this conduct is not serious enough to warrant revocation of my client's parole. Clearly, the prosecution in court in GA2 didn't find it serious enough by giving him just the unconditional discharge, didn't get any jail time, and no additional supervision. Additionally, prior to entering his plea, my client was given a written promise to appear in court and no bond, which I think also signifies this is not a serious situation. This is a situation where my client had been doing everything he was supposed to do in the community and while out on parole supervision. And but for this warrant being served, you would not have seen him back. He's been working long hours for years as a ballet coordinator at the Smilo Cancer Center, Yale New Haven Hospital. He really has built a career out of this, and this is a job that he loves. He doesn't drive the vehicles, but he takes the client's keys, gives them the valet tags, coordinates the other valet drivers, and provides directions and essentially runs the whole system there. At both the 35 Park Street and the 20 York Street location. His employer absolutely loves him, and they've been doing everything that they can to hold his position for him. But he is likely to lose that if he's held longer than April 9th. I think that was the last day that they were able to keep it open. So he does risk having a lot of the progress that he's made and success that he's built uprooted if he's not released soon. So I would argue as well, my client recently completed relapse prevention group on his own over the summer in Bridgeport at J Brothers program, and he's been maintaining in his also been prioritizing his sobriety since that point. He has a very strong partner who I spoke to earlier this week, who's very supportive of him and is challenging him to, be his best self and to further himself. And I would also argue that releasing Mr. Baker comports with the recommendation of the PO. They were just wanting him to remain incarcerated until his criminal case was resolved. And at this point, it has been. So I would argue that the conduct is not serious enough to warrant revocation of his parole. He just wants to get back out into the community to continue his supervision, continue doing what he was doing. And I appreciate your time and consideration.
Thank you very much.
Thank you.
I'm just going to take a moment before I announce my findings and recommendation. Okay, Mr. Baker, being that probable cause has already been established, however, I do not find that the acts are serious enough to warrant revocation. This is essentially your first parole violation. You've been in the community for approximately 1 year, and there was no reported issues within that time frame. Being that I don't find the act serious enough to warrant further revocation, your parole will be reinstated today. Okay? So I'm going to inform the facility that your parole is being reinstated today, and then you should be released today, being that you are on special parole. Okay?
All right, thank you, Miss.
Thank you.
Thank you.
Appreciate you. Yep. Keisha. Nice one.
Good morning, Mr. Bailey. I'm going to get started with you in just about a few minutes.
Okay.
Good morning, Attorney Jones.
Good
Give me
morning.
a moment. Thank you.
Yep.
Good morning. My name is Parole Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Ernest Bailey, inmate number 124565. Today is Tuesday, April 1st, 2025. This hearing is being conducted via video at the Board of Pardons and Parole Central Office in Osborne Correctional Institution. Please state your full name and DOC inmate number for the record.
Ernest Bailey, 124565.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is also your attorney.
Thank you. Attorney Sonia Jones, Public Defender's Office, Parole Revocation Unit, on behalf of Mr. Bailey.
This is a preliminary hearing, which has three purposes under Connecticut law: to determine if there is probable cause to believe you committed an act that violated the conditions of your parole, to determine if the act is sufficiently serious to warrant the revocation of your parole, and to determine if you should be held in prison pending further proceedings. The state, not you, has the responsibility to show that there is probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. Please note that you have been referred by the Department of Correction for diversion for substance abuse programming and treatment. If by the end of this hearing, I determine that you should be held in prison pending further proceedings, I will provide additional information about the diversion process. You should know that a preliminary hearing is an adversarial proceeding. Anything that you say at this hearing can be used against you. This hearing is being recorded. The testimony at today's hearing will be taken under oath. Mr. Bailey, please raise your right hand. You solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury.
Yes, I do.
Thank you. First, I will read you your rights. Then we will review the parole violation charges that the state your parole officer is bringing against you. Then I will review and identify exhibits filed for the record. Your attorney will have an opportunity to address the issue of probable cause and the severity of the allegations. At the conclusion of this hearing, I will inform you of my findings, which will be based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
No, I don't.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes, I do.
Thank you.
Parole Officer Saunders.
Yes.
My client is electing to waive the first portion of this hearing and to go forward with the second portion as he wishes to participate in the TOP program.
Thank you. I will accept that waiver, and I'm going to accept the waiver, and I find that the acts are serious enough to warrant revocation, and I also determine that you should be detained while you wait for your revocation hearing. The Department of Correction has recommended you for diversion from the revocation process for substance abuse programming and treatment. This means that if you wish to participate and apply, and I find that you meet certain eligibility criteria, I can continue your case while you are provided an opportunity to participate in substance abuse programs and treatment in a correctional facility. If you successfully complete the program and treatment provided, I will dismiss your case and order your parole reinstated. If you do not complete the program and treatment provided, the board will schedule and convene a revocation hearing to determine if you violated the conditions of your parole. If so, the hearing examiner will make recommendations regarding whether your parole should be revoked and what, if any, sanctions should be imposed. The decision to participate in diversion is voluntary. Do you understand the diversion process, and do you wish to apply for diversion?
Yes, I understand, and I would like to apply.
Thank you. I will announce your findings, or I will now announce my findings with respect to your eligibility. If I determine that you are eligible, I can accept your application and divert you from revocation. I have reviewed all relevant information, and my findings are as follows. I find that you have no pending misdemeanor or felony charges. I find that your discharge date is more than 60 business days from the date of remand to actual custody. I find that there is evidence that you have identified substance abuse treatment needs. I find that your substance abuse is reasonably considered to be a motivating factor in your alleged failure to comply with the terms and conditions of parole. And I find that there is some evidence that you have received or were provided with an opportunity to receive substance abuse programming or treatment during your parole supervision in the community. I have determined that you are eligible for diversion for substance abuse programming and treatment. Before I accept your application for diversion, I ask that you indicate whether you understand the following by answering yes or no. I understand that I will remain incarcerated while I receive programming and treatment, and that the parole revocation proceedings may be delayed as a result.
Yes, I do.
I understand that the dismissal of my case and reinstatement to active parole supervision is not guaranteed and is conditioned upon my successful completion of substance abuse programming and treatment.
Yes, I do.
I understand that ultimately the Department of Correction will determine whether I have successfully completed the substance abuse programming and treatment provided.
Yes, I do.
I understand that my participation in this process is completely voluntary.
Yes, I do.
Your application for diversion is granted. You will be placed in treatment or programming by the Department of Correction and diverted from revocation for no more than 60 business days. This concludes your preliminary hearing. Mr. Bailey, I know you're already in the top program, so you will just continue to engage.
Thank you very much. I greatly appreciate it. And thanks a lot, Ms. Jones. I greatly appreciate it.
No problem. Good luck. Okay.
All right.
All right.
Thank you.
Thank you.
Thank you.
Have a good one. Thank you.
Thank you.
There you go.
Morning.
Good morning.
Morning, my name is Parole Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Luis Ramirez, inmate number 434620. Today is Tuesday, April 1st, 2025. This hearing is being conducted via video at the Board of Pardons and Parole Central Office and Brooklyn Correctional Institution. Please state your full name and DOC inmate number for the record.
Luis Ramirez, 434620.
This is a public hearing. Public access to this hearing is available via video live stream. This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probable than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony at today's hearing will be taken under oath. Mr. Ramirez, please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes.
Thank you. First, I will read you your rights. Then we will review the parole violation charges that the state your parole officers bring against you. Then I will review and identify exhibits filed for the record. You will have an opportunity to present all relevant testimony. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, you will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No.
You have an important right to this hearing, which I now will review with you. You have the right to be represented by an attorney at this hearing. If you cannot afford an attorney, you may qualify for an appointed attorney to represent you. Do you intend to seek counsel for this hearing, or would you like to proceed without counsel?
Without.
You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes.
We now will review the charges that the state your parole officers bring against you and the information underlying each charge. Charge 1, residence. On February 6, 2024, you were arrested by law enforcement at 12-1 Ash Street in Waterbury, Connecticut, and you stated that you live at that residence several days a week. This is not your parole-approved residence, nor did you have permission to stay there. Charge 2, obedience to the law. On February 6, 2024, a team of both federal and state law enforcement agents entered a home in Waterbury searching for a murder suspect. You were found in the home and found to be in control and possession of a firearm, drugs, and drug paraphernalia. At this time, for your behaviors and actions, you were arrested and charged with criminal possession of a firearm, possession of a controlled substance, and use of drug paraphernalia. You were also arrested on an outstanding warrant for criminal mischief and disorderly conduct from an incident in Waterbury on September 25th, 2023. Charge 3, no contact with victims. When arrested on February 6, 2024, you were found in a home with YR, and YR is a parole stipulated victim of yours that you were aware that you are not to have any contact with and that you did not have prior permission to have contact with. The state has filed the following exhibits. Exhibit A, remand to custody order. Exhibit B, signed parole conditions. Exhibit C, notice of parole violation. Exhibit D, parole violation report. Exhibit E, Waterbury Police Report from February 6, 2024, and Waterbury Police Report from September 25th, 2023. The state found an addendum to Exhibit D, which states on February 27th, 2025, you were convicted of the substituted charge of carrying a pistol without permit. You were sentenced to 5 years jail, execution suspended after 1 year, followed by 3 years probation. The charges of possession of controlled substance first and the use of drug paraphernalia were nollied under docket ending in 858. In addition, the charges of criminal mischief third and disorderly conduct were also nollied under docket ending in 859. Did you receive the notice of parole violation report, and the other documents that were just marked for identification purposes?
Yes.
And did you have time to review the documents?
Yes.
Thank you. Today we have no witnesses. Now it is your opportunity to respond to the parole violation charges against you. However, remember that you may remain silent if you choose to do so. Do you wish to testify today?
Yes. On my prior preliminary hearing, charges 1, there was no findings made. Also on charge 3, there was no findings made. And it says for charge 1, bias, it says the behavior does not meet the element under obey all laws to meet the elements. Mr. Ramirez would have to leave his residence without intentions of returning. Mr. Ramirez testifies that the hearing, he does not reside at the residence. That was found by the last person that did the preliminary hearing. Also for charge 3, it states the evidence provided by the state of Exhibit D, parole violation report, and E, Waterbury Police Incident Report from 2/6/2024, which both state that YR was not present at any time during this incident. Mr. Ramirez also testifies that YR was not present during this incident. So that gave them no findings made for charge 3. The only charge I was still, disputing was the charge 2, the obedience of law. But as you said, the warrant for 9/25/23 was dismissed. And I also only got charged for pistol without a permit. And I was sentenced to a year. This dates back to 2/6/2024. And we are now in April 1st of 2025. So I believe I served the duration of the time needed for that crime. I was asking if I would be released on monitor and basically given the opportunity to prove myself. While on parole prior to this, I was doing very good. I went to all my meetings, completed all the programs, and didn't give a dirty urine or miss a meeting or anything like that with parole officer Dunn out of Hartford. And I wrote a letter here. I don't know if you would like to hear it.
Absolutely.
I said, good morning and thank you for the opportunity to speak at this vocational hearing. I sat for 14 months. During this time, I was able to reflect and work on myself and also reach out to programs and seek counsel from people that I look at to be community contributors. One of the programs willing to take me in upon my release is Project Longevity, which is a community-based program and provides services and programs for people who have gun convictions. It's a community based program, and it is upon my release that they will be able to take me in and do an intake. They also help with programming and also help with like the basics of being a successful community contributor and reentry into society. I spoke with one of the people who run it, and they are willing to also allow me to do the intake immediately upon release. I also found me a sponsor willing to let me stay with them upon my release and guaranteed me a job, which would be in a new environment and out of Waterbury. It would be an infield. While on parole, I held a job the entire time. I followed all stipulations when it came to the monitor on my ankle when I first came home. I did all the programs and did everything that was required from me for parole. All I'm asking for is to be considered as a opportunity to prove myself. I've learned my lesson, and I'm just trying to better myself. Again, as I stated, I was sentenced to a year. As of right now, it would be 14 months. I was also credited jail credit from the judge, but due to the fact that I didn't have my parole revoked yet, it's not able to be credited to me because of statute 1898D, because I was still serving on parole. So I'm not allowed to get the jail credit given to me by the judge that told me I was able to get jail credit. I'm not giving an excuse for my actions. I just want to take accountability, and also I feel like I've done that within the 14 months that I've been incarcerated. So I'm just asking for the opportunity to be re-released on a monitor and basically able to the chance to prove myself.
Thank you. So just to inform you, being that you, like you said, you didn't receive the jail credit, so your end of sentence, your estimated end of sentence as it stands is February 26, 2026. And
Yes.
your earliest release date based off of your 50% eligibility date wouldn't be until August 26, 2025. That would be the absolute earliest you could be released due to the parole eligibility, your 50% parole eligibility date. Okay,
Okay.
just so you're aware. Nothing further before I make my findings?
No.
I think. In regards to charge one, residents, there was a no finding made, as you stated, at your preliminary hearing held on February 26, 2024. There was no further evidence submitted regarding this charge, therefore it will not be considered for today. In regards to charge number two, obedience to law, I make a finding based off of Mr. Ramirez's conviction as well as state's exhibits B, D, and E. In regards to charge three, no contact with victims, there was also no finding made at the preliminary hearing held on February 26, 2024, and there was no further evidence submitted. Therefore, charge three will also not be considered at today's hearing as well. That concludes the fact-finding portion of this hearing. Before I make my recommendation, you will have an opportunity to speak to your background and history. I heard in your statement that you have a sponsor and you have a potential job opportunity. Who is your sponsor?
Her name is Waleska.
Can you spell that for me?
Waleska, I believe.
Okay, last name?
Calderon, Caldeon, I believe. I'm not sure.
Okay, and what is her phone number?
Give me 1 second.
Mhm.
Eight 860.
Yep.
394 9536.
And what is her address?
I don't know exactly the full address by hand, but I know she lives out of Enfield.
And what would be your employment opportunity? You said it's also in Enfield?
Yes, that's also in Enfield. Her husband and her work for a company, and they're willing to give me the opportunity of working with them.
And what is the company's name?
I didn't find out that far because we were still trying to figure out around what time I would be released and things like that. So she just told me that the opportunity, due to the fact that I had the vocational hearing today, that the opportunity would be open until the end of May.
Understood. Okay. And do you have a backup plan, like a halfway house option or another sponsor?
I wouldn't mind going to a halfway house, but I'm pretty sure that the person that I gave you would be approved. She owns her own house, and she doesn't have any like prior backgrounds or anything like that. So from what I was told, the requirements for a sponsor, she would fit the criteria for.
And do you want to say anything else regards to your background and history?
Like I said, while I was on parole, I maintained the job. I completed the programs. I did everything asked for from parole. I'm just trying to get another chance to go out there and show that I can do the same thing that I was doing in the beginning.
Anything further before I make my recommendation?
No, ma'am.
Thank you very much. I'm going to just take a moment before I inform you of my recommendation. Okay, Mr. Ramirez, I see that you were released on transfer parole in October 2022. So that was how long you were in the community until your remand in February 2024.
Yes.
In that time, there were no reported sanctions or misconducts that were reported. However, you were on discretionary parole while you committed this offense, and this offense was pretty significant. Taking that into consideration, I recommend revoke with no new reparole date, which is an approximate 25-month sanction. And in the event that the board chooses to lessen the recommended sanction, I recommend the following conditions: domestic violence, no contact with co-defendants JM and JC, a general no contact with TW, no contact with victim YR, and halfway house placement in the event that it is needed. My findings and recommendations will be forwarded to the board, and you will receive the official written decision from the board. And your board review is scheduled on April 10th, 2025. So next Thursday, the board is going to take a look at your case. My recommendation is no new parole date, but the board can lower that sanction. And if they do, the earliest they can lower that sanction is until until August 2025. That's the lowest, the earliest you could be released. But again, you'll receive a written decision from the board within a week of April 10th, informing them of their final decision.
Okay.
Okay. Thank you so much. Go ahead.
Can I ask, why would you ask for like no new parole?
So I stated that it's pretty significant. And that is what your end of sentence is. So that's my recommendation. And you will also receive everything in writing as well. And again, the board can definitely go lower, but again, if they do go lower, the earliest they can go is August 2025. Okay.
So I wouldn't be able to serve a sentence while being on the bracelet, considered like a level 1.
If the board goes lower, you can absolutely be released, but again, not until August 2025. And then if you are released, then it would be up to your parole officer in the community if they decide to put you on a bracelet or not. If the board lowers the sanction.
Okay, so if they don't lower the sanction, would I still be eligible for TS in August?
No, if they don't, you go to your end of sentence.
So okay, so
Yeah,
I wouldn't be eligible for transitional supervision for TS.
You're on discretionary parole as well, so you would go until your end of sentence. If they don't recommend an earlier release date, if they go to your end of sentence, go to your end of sentence.
Okay.
Okay.
Yeah, I was just asking because I know DOC says that the crime that I committed was a 50% charge. And due to the fact that it happened over a year ago and I only got sentenced to a year, that's what's like confusing me. So I'd have to do an additional year on top of the year that I already did.
Yeah, because the jail credits didn't apply.
All right.
Okay, thank you very much.
Thank
You're
you.
all set. Good morning, Officer Hudabenko.
Good morning. How are you?
Well, we should be getting started in a few minutes once the facility gets on the phone.
Perfect. Sounds good. Thank you.
Thank you. Good morning, Mr. Hunter. Mr. Bowman, I'm sorry.
Good morning. Should be good.
We're going to get started in just a few moments. Thank you. Good morning. My name is Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Hunter Bowman, inmate number 443543. Today is Tuesday, April 1st, 2025. This hearing is being conducted via video at the Board of Pardons and Paroles Central Office in Cybulski Correctional Institution. Please state your full name and DOC inmate number for the record.
My name is Hunter Bowman, 443543.
This is a public hearing. Public access to this hearing is available via video live stream. Also present this morning is your parole officer.
Good morning. Nicholas Hudabenko, parole officer, Hartford Special Management Unit.
This is a preliminary hearing which has three purposes under Connecticut law: to determine if there is probable cause to believe you committed an act that violated the conditions of your parole, to determine if the act is sufficiently serious to warrant the revocation of your parole, and to determine if you should be held in prison pending further proceedings. The state, not you, has the responsibility to show that there is probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding. Anything you say at this hearing can be used against you. This hearing is being recorded. The testimony at today's hearing will be taken under oath. Mr. Bowman and Pio Hudabenko, please raise your right hand. Do you solemnly swear, or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Yes, I
Thank
do.
you. Thank you very much. First, I will read you your rights. Then we will review the parole violation charges of the state your parole officer is bringing against you. Then I will review and identify exhibits filed for the record. Both you and the state will have an opportunity to address the issue of probable cause and the severity of the allegations. At the conclusion of this hearing, I will inform you of my findings, which will be based on the available evidence. Mr. Bowman, do you have any questions about the purpose or procedure before we begin?
No.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You may hire your own attorney. If you cannot afford an attorney, you may qualify for an appointed attorney to represent you. Do you intend to seek counsel for this hearing, or would you like to proceed without counsel?
Believe I'll get an attorney.
You would like an attorney?
Yes.
Okay, so what I'm going to do is I'm going to continue your hearing so you can obtain an attorney. And my next available hearing date is April 21st, 2025. Okay? So I'm going to refer your case to an attorney or to see if you're eligible. And if you're eligible, then you would receive representation. But they will inform you if you're eligible or not, okay?
Okay.
All right, so I'm going to continue this hearing until April 21st, 2025. Okay, so you're all set. Thank you very
All right.
much.
Thank you.
Thank you, PO Odobago.
Thank you very much.
All set. All set.
Morning.
Oh, okay.
Do you hear me?
Yes.
Okay, we're gonna start it in just about a minute or so.
Good morning, Kurt.
Hi, how are you?
Good.
Good morning, my name is Parole Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Kurt Geren, inmate number 246873. Today is Tuesday, April 1st, 2025. This hearing is being conducted via video at the Board of Pardons and Parole Central Office and Hartford Correctional Center. Please state your full name and DOC inmate number for the record.
Kurt Geren, 246873.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is your attorney.
Thank you. Attorney Sonia Jones, Public Defender's Office, Parole Revocation Unit on behalf of Mr. Geren.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probable than not the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your paroles, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony at today's hearing will be taken under oath. Mr. Geren, please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Thank you very much. First, I will read you your rights. Then we will review the parole violation charges that the state your parole officer is bringing against you. Then I will review and identify exhibits filed for the record. Your attorney will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, your attorney will have an opportunity to speak to your background and history. Mr. Geren, do you have any questions about the purpose or procedure before we begin?
No.
Thank you. You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes.
We now will review the charges that the state your parole officer is bringing against you and the information underlying each charge. Charge 1, GPS. On November 20th, 2024, you failed to charge your GPS unit in accordance with your signed GPS monitoring agreement, resulting in a full shutdown of the device from 6:41 p.m. until November 21st, 2024 at 8 a.m. You were in the hospital on November 20th, 2024. However, this PO provided you with your charger at the hospital prior to your battery shutdown and instructed you to charge the device. On November 22nd, 2024, you failed to charge your GPS unit in accordance with your signed GPS monitoring agreement, resulting in a full shutdown of the device from November 23rd, 2024 at 3:13 a.m. until 8:37 a.m. and again on November 23rd, 2024 at 10:46 a.m. until 11:20 a.m. Charge 2, legal obligations. On January 31st, 2025, this PO was informed by your DCF worker that you failed to attend a required DNA test on January 30th, 2025 that had been scheduled by DCF.
If I may,
but
PO Saunders, yes, I don't know if it's, I just didn't know if you recalled that and if it was necessary to read it, but.
Yeah, I was going to read it and say that there was no additional evidence provided by the state. And so there was no finding made. And won't be considered at today's hearing. So, yeah. So in regards to charge 3, then, drugs, on October 31st, 2024, you used cocaine. On charge 4, no consumption of alcoholic beverages. On October 31st, 2024, you submitted a breathalyzer test to the staff of the Watkinson Halfway House, and the result was positive at a level of 0.172. Charge 5, halfway house placement. No finding was made. Hold on, let me make sure. No finding was made on parts 1 and 2 of the preliminary hearing held on February 24, 2025, and there was no further evidence submitted by the state. Therefore, these 2 charges under charge 5, halfway house placement, will not be considered. On November 12, 2024, you signed out of the Watkinson Halfway House at 1:18 p.m. to attend a 2 p.m. appointment at Hartford Hospital with a return time of 4:20 p.m. You sent an email to the Watkinson Halfway House staff at 2:30 p.m. stating your appointment was canceled, despite being given direction to contact staff via phone call for these matters. Staff contacted Hartford Hospital to verify the cancellation, and you were informed that you were called and informed of the cancellation by the hospital at 1:30 p.m. Despite this, you did not immediately report back to the halfway house and remained signed out until 3:13 p.m. On November 19th, 2024, you signed out of the Watkinson Halfway House at 4:42 p.m. for a pass to attend an appointment at CRT. You returned from your pass at 7:44 p.m. Your pass was only to attend CRT on Market Street. However, you made an unauthorized stop at the pharmacy on Washington Street in Hartford. On January 20th, 2025, you signed out of the Watkinson Halfway House to attend work at AD USA warehouse from 12:21 p.m. until 3:56 p.m. Upon Watkinson Halfway House staff completing a check of your employment status on January 23rd, 2025, Watkinson staff was informed by Human Resources at AD USA that you did not report to work that day despite signing out to do so. On January 31st, 2025, you signed out of the Watkinson Halfway House at 11:15 a.m. to attend treatment at CRT with a return time of 2:45 p.m. You failed to return to the halfway house until 4:21 p.m. and stated you made an unauthorized stop at Walgreens, which was not on your approved community pass. On February 5th, 2025, at approximately 10:55 a.m., you exited the Watkinson Halfway House without authorization and without an approved community pass and did not return until 2:05 p.m. The state's exhibits were marked and identified at the preliminary hearing held on February 24th, 2025. Counsel, did you receive the notice of parole violation report, and other documents that were marked for identification purposes?
Yes.
And defense has filed Exhibit 1, parole accomplishments and future plans for parole reinstatement. Today, we have no witnesses, and it is now the defense opportunity to present evidence and speak to any of the evidence submitted. Counsel?
Yes, thank you. In regards to charge 1, GPS under release direction, my comments from the preliminary hearing stand. We would submit there's insufficient evidence to support that charge. Namely, my client was in the hospital after suffering a medical emergency associated with a change in his medication. Prior to being admitted, he was in a bed in the hallway of the hospital with no ability to charge the GPS. I understand that the parole officer did arrive to the hospital to provide him with a charger, but the point is he had an inability to charge that device. In addition, once he was placed in an actual room, my client was not in a condition to make the GPS charging a priority. He was there being treated for a medical emergency. Therefore, we submit there's insufficient evidence to support this charge, as it was physically impossible for Mr. Geren to maintain the charge on the GPS during that time period that he was in the hospital, considering his medical emergency. No comment as to the remaining paragraph. Again, I would just indicate that my comments from the preliminary hearing would stand. In regards to charge 5, halfway house placement, jumping to the third paragraph, which begins on November 12th. My client alleges that he was notified of the cancellation by 1:30, or I'm sorry, the charge alleges that my client was notified that his appointment was canceled by 1:30 by quote unquote the hospital. The state fails to identify who provided such notification and proof that that notification was in fact given to my client on his phone number. There's no indication that the hospital, again, that's a entity, not a person, spoke with him directly or left a voicemail message for him. But if my client was left, but if my client left for his appointment at 1:18, which it indicates that he did, it's reasonable, absent any evidence to the contrary, that he arrived at the appointment later and learned it was canceled and started to head back to the halfway house. The hospital is located on Jefferson Street, and the Watkinson Halfway House is located on Collins Street in Hartford, and my client was traveling by foot. There's no evidence that my client went to any other location other than which was authorized by his pass. So lastly, the state failed to submit a copy of the pass, so we don't really know what time and place the pass was authorized for. Based on all of those circumstances, we would submit there's insufficient evidence to support that portion of the charge. And then if I could just have one moment. And then addressing the paragraph November 19th, my client attended his appointment and then stopped at the pharmacy to pick up his new medication prescription. It was ultimately an adverse reaction to that medication that led to him being admitted to the hospital in the emergency room. So the deviation isn't to do anything nefarious. He's going to pick up his prescription medication at the pharmacy. So we would submit there's insufficient evidence to support that charge. In regards to the paragraph January 20th of 25, we would submit there's insufficient evidence to support this charge. My client does maintain that he was en route to his employment via public transportation. When he contacted his boss to inform him that he believed that he was going to be late, his boss then told him that based on a snowstorm that had occurred, the dock at his work location was covered in snow, that he didn't need to report that day. So again, the state fails to provide the information regarding who the individual was that they spoke to at Human Resources. They don't indicate that they spoke to his boss. In addition, they failed to allege where my client was supposedly went other than an attempt to go to his place of employment. So based on all of that, we would submit there's insufficient evidence to support that charge. And then nothing further as to the remaining paragraphs.
Thank you. I'm going to take a moment before I announce my findings. Regarding charge 1 GPS, I make a finding based on state's exhibits D, P, S, T, U, V, W, X, and JJ. Charge 2 legal obligations, and no finding was made at the preliminary hearing held on February 24, 2025, and was not considered at today's revocation hearing. Charge 3 drugs, make a finding based on state's exhibits D, M, N, O, and JJ. Charge 4, no consumption of alcoholic beverages. I make a finding based on state's exhibits D, I, J, and JJ. On charge 5, halfway house placement, a no finding was made on parts 1 and 2 at the preliminary hearing held on February 24, 2025, and was not considered at today's revocation hearing. However, I make a finding on the rest of the parts listed in this charge based on state's exhibits D, E, G, H, I, J, K, L, Q, R, B, B, C, C, G, G, H, H, I, and J, J. That concludes the fact-finding portion of this hearing. Before I make my recommendation, your attorney will have an opportunity to speak to your background and history. Counsel?
Yes. Mr. Geren is 45 years of age. He's single. He has 2 children, a 7-year-old and an 8-year-old. They reside in East Hartford, Connecticut. He does receive support in the community, which consists of his girlfriend, who he's been with for approximately 11 years. He did graduate from high school, attending Walcott High School in Walcott, Connecticut. He does live with both mental health as well as substance abuse issues. And I think it's unfortunate, in considering the nature of this violation, that he was not referred for the top program. Certainly, I think it would have been appropriate. He was in the community for approximately 8 months. And during the time period that he was in the community, he did enjoy many successes. He was attending college at Goodwin University in East Hartford, studying underwater welding. He was working multiple jobs at the Tavern in Windsor, Amazon, located in Windsor as well, and then most recently at ADUSA in Manchester. He was attending treatment, individual therapy with a private provider. He was attending, receiving outpatient and medication management through, he completed 7 sessions of that. He attended the App Foundation inpatient treatment services as well. And then during the time period that he's been in the Department of Corrections, he's been attending methadone, receiving methadone, as well as attending medication-assisted treatment group therapy biweekly. And then when he was in the community, he was also receiving methadone through the Fish Fry Clinic located in Hartford. When he's released back into the community, he's asking to be placed in a halfway house in the Hartford area due to the proximity to his school, work, and family. He initially indicated that he wanted to go to a sober house. However, the strategy of planning that in relation to getting a re-parole date is sometimes quite difficult. And so he just wants that to be known that that is his ultimate goal, that he would like to end up in a sober house in the Vernon area. And this is his first violation of parole. Based on all of those things, we would be asking that he be re-paroled at the next available date. Thank you.
Thank you. I'm going to take a moment before I announce my recommendation. Hey, Mr. Geren, I have that you were in the community since June 7th, 2024, when you were first discharged to special parole. In that time frame, which was an approximate 7.5 months, you received about 12 misconducts for various GPS shutdowns, being unaccountable in the community through halfway house, from the halfway house, as well as drug use. Taking all that in consideration, being that this is your first violation, you were in the community for 7.5 months and received a number of PCS misconducts, I recommend revoke and re-parole on July 3rd, 2025, which is an approximate 5-month sanction with the following conditions: no consumption of alcohol, halfway house placement, mental health evaluation, and no operation of a motor vehicle without the express permission of your parole officer. My findings and recommendations will be forwarded to the board. You will receive their official written decision, and your board review is scheduled for April 10th, 2025, which is next Thursday. So next Thursday, the board is going to review your case. My recommendation is 5 months. They can lower that recommendation, they can adopt that recommendation, or they can exceed that recommendation, meaning that you're on supervision until June 2026. Okay, but you'll receive whatever decision they make in writing as well. Okay.
Okay, thank you.
Thank you.
If you have any questions, you can contact me after that date, okay? After the April 10th date, and I can let you know what the board did, okay?
Okay.
Okay. All right, Kurt, good luck.
All right, thank you.
You're welcome. Thank you, Hearing Examiner Saunders.
Thank you. Have a great afternoon, Attorney Jones.
You as well.
Hi, good afternoon.
Hi, how are you?
Good. Should be having Mr. Baker for 12 o'clock.
So I just sent him back. I just spoke to the council supervisor. I didn't have him on the computer schedule. So she said that she made a call and she told us that he was canceled today.
No,
You want me-
Diaz was continued, requested to still see Baker.
How much time do you have? Do you want me to try and get him back down here?
Yes, please.
All right, let me see what I can do. Just stand by, okay?
Thank you.
All right, ma'am, it'll be a couple minutes. He's on his way down.
Okay, thank you.
Ma'am, so you said Daniel Diaz is actually canceled today?
Yes, he's continued, so he will not be present this afternoon.
Okay. So that's the only one you have today is Baker.
Correct.
All right, I just have conflicting schedules, so thanks for bearing with me.
No problem. There's currently a delay regarding inmate number Ronald Strano, inmate number 57303. And once I receive confirmation regarding his status from the facility, I will provide an additional update. At this time, there is a delay. Also regarding Daniel Diaz, inmate number 111445, his case is continued until April 21st, 2025, and will not be heard today.
Yeah. This confusion was,
Good afternoon, Mr. Baker.
How you doing, man?
Good. My name is Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Michael Baker, inmate number 338041. Today is Tuesday, April 1st, 2025. This hearing is being conducted via video at the Board of Pardons and Parole Central Office and Corrigan Correctional Institution. Please state your full name and DLC inmate number for the record.
Michael Baker, 338041.
This is a public hearing. Public access to this hearing is available via video live stream. This is a preliminary hearing which has three purposes under Connecticut law: to determine if there is probable cause to believe you committed an act that violated the conditions of your parole, to determine if the act is sufficiently serious to warrant the revocation of your parole, and to determine if you should be held in prison pending further proceedings. The state, not you, has the responsibility to show that there is probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding. Anything you say at this hearing can be used against you. This hearing is being recorded.
Yes, ma'am.
The testimony at today's hearing will be taken under oath. Mr. Baker, please raise your right hand.
Sorry.
Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes, ma'am.
Thank you very much. First, I will read you your rights. Then we will review the parole violation charges that the state your parole officer is bringing against you. Then I will review and identify exhibits filed for the record. You will have an opportunity to address the issue of probable cause and the severity of the allegations. At the conclusion of this hearing, I will inform you of my findings, which will be based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
Say that again?
Do you have any questions about the purpose or procedure before we begin?
No.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You may hire your own attorney. If you cannot afford an attorney, you may qualify for an appointed attorney to represent you. Do you intend to seek counsel for this hearing, or would you like to proceed without counsel?
Proceed without counsel.
You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes, ma'am.
We now will review the charges that the state your parole officer is bringing against you and the information underlying each charge. Charge 1, obedience to the law. On February 12th, 2025, you sent multiple text messages and a voicemail to the victim stating that you were going to cause him physical harm. On March 13th, 2025, the Norwich Police Department executed an arrest warrant for the charge of breach of peace due to your criminal actions. You were subsequently arraigned at GA 21 Norwich on March 14th, 2025, and then remanded to custody at Corrigan Correctional Center. Charge 2, mental health evaluation and treatment deemed necessary. On January 14th, 2025, you completed a mental health evaluation at Rushford and Middletown, and you were recommended to participate in mental health co-ed intensive outpatient groups 5 times per week. You completed IOP groups, and you were then enrolled in mental health relapse prevention groups, Our Path, Our Journey, to begin on February 25th, 2025. On March 4th, 2025, you failed to attend your scheduled relapse prevention group as required. The state has filed the following exhibits. Exhibit A, remand to actual custody order. Exhibit B, signed PCS conditions. Exhibit C, notice of parole violation and parolee rates. Exhibit D, parole violation report. Exhibit E, halfway house agreement. Exhibit F, emails from Todd Maloney at Rushford. Exhibit G, Eddy Center residential discipline report. Exhibit H, offender misconduct report. Exhibit I, Norwich Police Department, signed arrest warrant. Exhibit J, State of Connecticut Judicial Branch pending case detail. Exhibit K, parole violation and evidence, technical violation dating back to December 30th, 2024. Mr. Baker, did you receive the notice of parole violation report, and the other documents that I just marked for identification purposes?
They just sent me a big packet with a whole bunch of stuff, like the arrest warrant, all that stuff. Yes, they have, yes.
Okay, and did you have time to review it?
I went through it, and so there's a couple of things in there I disagree with, so I'll let you know about that when it comes to that time. But other than that, yes, I did look at it, went over and stuff like that, yes.
Thank you. So today we have no witnesses. It is now your opportunity to respond to the parole violation charges against you. However, remember that you may remain silent if you choose to do so. In regards to charge 1, obedience to the law, on March 12, 2025, a state of Connecticut Superior Court judge determined that there is probable cause to believe you committed breach of P2. Therefore, I cannot revisit this finding. But you can still speak to the severity of that charge, and you also can speak to probable cause and the severity of the mental health charge, mental health evaluation and treatment deemed necessary charge.
Okay, so the mental health one, I'm not too far, understand what's that mean? Like I'm being violated because I didn't do the mental health stuff?
They're saying that you missed one group, yes, yeah.
So how can I be violated and this is one thing I wanted to say about that too. The day I missed that group, I was at work and stuff. It wasn't like I just went out on the pass to hang out and do some stuff. I was actually at work, pretending I was actually working that day and stuff. And like I was working for People Ready. So like the days we schedule like whatever time the day on the app you actually pick your days and stuff like that whenever they have a job available. So the jobs that I picked was for the week. So when I picked the job on Tuesday at like it was how can I say a brain fart? I'm not to sound crazy, but not realizing I forgot I had my group that day, and it was my second group. It wasn't like I missed multiple groups and all that in that relapse prevention group. It was my second group. You get what I'm saying? So I completed outpatient 5 days a week. I flying colors, never gave them a dirty urine and nothing like that. Never gave the halfway house a dirty urine, nothing. I've been clean over 90 days. You get what I mean? Since I went back in the first time for the violation, the technical. You know what I'm saying? When they actually put me in a halfway house. I've been doing good since then. You get what I mean? Working, doing what I got to do. It was a misunderstanding with that group that day. It wasn't like I just wanted to miss it intentionally. So like when they woke me up with that, I set the consequences. They woke me up. I wasn't allowed to go out on regular passes for 2 weeks. I completed that. And like I was still going to my NA meetings. I was still doing the day I was supposed to go back to the group, I ended up going back to jail. I came back in from work. They had state troopers there and they brought me back in. You get what I mean? So it wasn't like I wasn't trying to do better myself or put myself in a better position when I went to that halfway house, because I was. You get what I mean? So like my case manager, she could validate that was in the Eddy Center. I was actually doing good. You get what I mean? I wasn't messing around, getting high, doing stupid stuff that I wasn't supposed to be doing. Well, like I said, I don't want to say about the putting that as a violation or whatever it is for that mental health stuff. Like I said, I missed one group. It was a technical. It shouldn't be a violation. You get what I mean? And I was still attending. You get what I mean? It wasn't like I wasn't attending it. You get what I mean? The first charge that you said for the breach of peace charge, like, I really don't know what to say about that. I really don't. Like, it was a heated conversation. You get what I mean? Between both parties. It wasn't just a situation with me. It was a heated conversation. Stuff got out of control. I known the kid over 10 years. You know what I'm saying? It's like, it's not like we haven't been friends. We've been friends for a long time. He's going through stuff. I was going through stuff. It was, like I said, it was a heated conversation and got out of hand. That was it. You know what I'm saying? I was all the way in Middletown. It wasn't like I was in Norwich and I couldn't go to Norwich anyways. You get what I mean? If I would have went to Norwich, it would have been a violation of my special parole. You get what I'm saying? I understand about you can't threaten people. I understand that. I understand you can't do stupid stuff like that. But like I said, at that point in time, at that heated time or moment, something going through your head, you know what I'm saying? All you can think about is saying dumb shit out your mouth. Sorry, my swearing. I apologize for that, man. You know what I'm saying? But it was, like I said, it was a heated conversation between both parties. It wasn't just on one part. It was on both parties. You get what I mean?
Thank you. Anything further before I announce my finding and recommendation?
I'm being violated for the breach of peace and the mental health thing.
So that's what that's what the state filed the violation for. Yes, and I'm going to now either make findings or no findings. Well, again, in regards to the obedience to the law, the court already established probable cause there. So
I know that. I already know that. Yeah.
Mm-hmm. Yeah, so that's what you're being charged with the mental health evaluation as well as the obedience to the law. So I'm going to now go into my findings unless you have something else to say.
Like I said, like my opinion is I made a mistake. You know what I'm saying? Nobody's perfect. You get what I mean? Like, I am trying to change my life over. I am trying to do better. And like I said, like if you guys give me the opportunity to go back out into a halfway house, I'm going to proceed what I was doing to stay on the sober path and keep on working so I can eventually either go to a sober house or go into my own reach bed. Because that was the plan before this situation happened. I was waiting 2 days before, 2 days before this happened, when I went back to jail on this, I was waiting for an intake in New Haven for a sober house out there. So like I said, it was like I was on the right path, and I said I made a mistake. You get what I mean? I shouldn't have let that situation happen, but it did. You get what I mean? I can't take it back now, but I wish it was a different outcome. You get what I mean? Because I do got love for the kid, no matter what the situation is. Like, we've been friends for almost 15 years. You get what I mean? So it was like I said, it was a heated thing. But other than that, like I said, it was an honest mistake, stupid situation that I shouldn't have let myself get involved in.
Thank you. Again, in regards to charge 1, obedience to the law, probable cause was already established. On charge 2, mental health evaluation and treatment deemed necessary, I make a no finding of probable cause as the state failed to provide sufficient evidence that Mr. Baker's actions meet the elements of the charge. I do find that the acts are serious enough to warrant revocation, and I have determined that you should be detained while you wait for your revocation hearing. Being that, so your revocation hearing will be scheduled upon the disposition of your pending criminal case. So once we get the disposition, then you'll be scheduled for a revocation hearing, okay?
Now, I just got a quick question, if you don't mind me asking. Now, usually say for some reason, like if I get time served on that case, right? Now, I still got to go to the hearing after that, no matter what, and if they choose to agree with what the court says, that's what usually happens. Like, I've never been to one of these. That's why I'm asking.
So it depends. So the hearing examiner will take into account the totality of your history, as well as this current violation, as well as the court disposition. So it all depends at the time your case is disposed of. And at that hearing, the hearing examiner will inform you of the reasons why. You get everything in writing, as well as to the decision that would be made.
Okay.
Okay.
All right. So you basically the mental health stuff is not a violation.
I made a no finding on that. There was no, I didn't make a finding on that. Yep. But in terms of the obedience to the law, yes, because the probable cause was already established. Yep.
All right.
So
thank you.
Yeah, Mr. Baker, you're all set. Thank you.
Have a nice day.
You too. Hi, good afternoon.
Hi.
I'm looking to have a hearing with Mr. Strano.
Okay, so they put it on this side.
All right, so
Yeah.
we're in the wrong room.
Yeah, just tell him to come this room. He's here.
Okay, thank you.
Number one, walk me back there. They got jokes. Hello,
Good afternoon, Mr. Strano.
good afternoon.
My name is Pro Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing concerning Ronald Strano, inmate number 57303. Today is Tuesday, April 1st, 2025. This hearing is being conducted via video at the Board of Pardons and Parole Central Office in McDougal Correctional Institution. Please state your full name and DOC inmate number for the record.
Yes, my name is Ronald Strano. And my inmate number is 57303.
This is a public hearing. Public access to this hearing is available via video live stream. This is a preliminary hearing, which has three purposes under Connecticut law: to determine if there is probable cause to believe you committed an act that violated the conditions of your parole, to determine if the act is sufficiently serious to warrant the revocation of your parole, and to determine if you should be held in prison pending further proceedings. The state, not you, has the responsibility to show that there is probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that a preliminary hearing is an adversarial proceeding. Anything you say at this hearing can be used against you. This hearing is being recorded. The testimony at today's hearing will be taken under oath. Mr. Strano, please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
So help me God, I'm telling the truth.
Okay, thank you. First, I will read you your rights. Then we will review the parole violation charges that the state, your parole officer, is bringing against you. Then I will review and identify exhibits filed for the record. You will have an opportunity to address the issue of probable cause and the severity of the allegations. At the conclusion of this hearing, I will inform you of my findings, which will be based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
No, I understand completely now.
Thank you. You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney, or you may hire your own attorney. If you cannot afford an attorney, you may qualify for an appointed attorney to represent you. Do you intend to seek counsel for this hearing, or would you like to proceed without counsel?
Well, that's just it. I don't know whether I need one or not. You understand what the situation was here?
Yeah,
had
I have the
masks.
violation.
We had masks on. I said, "Come," they heard God.
Mr. Strano, so we're going to get to a point where you're going to be able to testify to the charges. But before we get there, I would need to know if you want attorney representation.
I'll waive the attorney.
Okay. You also have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes, I do.
We now will review the charges that the state your parole officer is bringing against you and the information underlying each charge. Charge 1, obedience to the law. On March 10th, 2025, Manchester police were dispatched to Manchester Dialysis on the report of a threatening complaint. On arrival, the officer spoke with a dialysis technician who was attending to your treatment. She reported that you informed that you could not cover the port in your arm with a blanket. As a response to this instruction, you told her to get out of here. I'll bring my gun. She reported that on previous occasions, you have threatened to bring a baseball bat to the facility to destroy the machines. A second employee was directly behind you at the time, reported to Manchester police that she heard you state that you were going to get a gun and bring it to the dialysis center. Based on your actions, you were arrested and subsequently charged with breach of peace second and threatening second, violence to terrorize. You were arraigned at GA 14 on March 11th, 2025. Probable cause was met and your bond was set to $5,000 with a next court date of April 1st, 2025. The state has filed the following exhibits. Exhibit A, signed conditions of parole. Exhibit B, remand to actual custody order. Exhibit C, notice of parole violation. Exhibit D, parole violation report. Exhibit E, Manchester police report, case incident report. Exhibit F, State of Connecticut Judicial Branch pending case detail. Exhibit G, Board of Pardons and Parole Decision Information Summary. Mr. Strano, did you receive the notice of parole violation report, and the other documents that I just marked for identification purposes?
Yes, I believe I did. I got those in the mail. Matter of fact, I just got those yesterday.
Did you have time to review all the information?
Not all of it, but a good part of it.
Would you like to proceed with the hearing, or would you like more time to review the evidence?
No, I'd like to proceed because I read the charges that I'm being charged with. They make no sense.
Today, we have no witnesses, and it is now your opportunity to respond to the parole violation charges against you. However, remember that you may remain silent if you choose to do so. Would you like to respond to the charges at this time?
Yes, I would.
Okay, this is now your opportunity to do so.
Okay. Number one, it makes no sense to bring a gun into dialysis and to destroy a machine that is actually keeping me alive. That makes no sense. I have never threatened to bring in a baseball bat, but we were talking about the machines at one point where they weren't working properly. And I made a comment, hit them with a hammer. Hell, it's just a phrase. People laugh when you say it because it sounds stupid when you say it. But sometimes if you tap the machine a little bit, it works better. I'm in a corner in dialysis. Now, I don't know of any other techs that were around or nurses other than the one. So I don't know how somebody else got involved in this. But again, it was a simple mistake, misunderstanding. I said gum. Here's the situation. I asked for another glass of water because dialysis dries you out terribly. And my throat was getting very, very dry down into my esophagus. So I said, could I please have another glass of water? I'm getting very, very dry. And she says, Mr. Strano, no, she says, Ron, we're trying to take the fluid off of you, not put it back on you. I said, but I'm getting very dry. She says, no, I'm sorry, I can't do it. I said, okay. I should have brought my gum in with me. I should have said chewing gum, and there wouldn't be any, we wouldn't be sitting here right now. But I didn't. I said gum with the mask on. You all have masks on because our immune system is compromised. So we all wear masks. As far as my port being covered, yes, I admit it gets cold in there. That's why I have a heating blanket. I covered my port. She came over to me and jokingly, because I've done it before, told her to get away from me. Jokingly. I don't know what else to say. This is one big, big, big misunderstanding, and it's flipped my life upside down. Since I've been arrested, this has flipped my life upside down. I'm 74 years old. This ain't an old man's game no more. This is a young guy's game, if that's what you want to call it, for lack of the right word. I've been out 5 years after doing 22.5 years of good behavior. I did straight time. You can ask any one of the COs in here that know me, that are left, and any one of my captains. I've been out 5 years. I haven't even had a parking ticket. I've done everything the right way because I don't want to go back. The only reason I went in was because I was strung out on dope. And that's what made me rob the 7-Eleven. And then they hit me with 13 more charges than I actually did. I did a smoke shop, a 7-Eleven, and I went to go do a Dunkin' Donuts. But when the attendant turned around and I saw he was autistic, I couldn't do it. I walked out and I was dope sick. Now, all that is behind me. All that is behind me. But I've got this. I report once a year. Mr. Whitaker, who I had as a parole officer, had me sign up for once a year. And he'd come to me, come to my apartment, sit down, have coffee, we'd talk, and he'd give me the next appointment date for a year later. And now I have a new parole officer who I know and we get along good. Ms. Bennett will vouch for me, I'm sure. I know Mr. Winokur will. I'm not that person. I'm not that person. But to threaten to bring a gun into dialysis and shoot a machine that's keeping me alive? Do I look that stupid? I don't know what else to say. I want to go home.
Okay, Mr. Strano, I'm going to take a moment before I announce my finding.
Yeah, he's not ready yet. I'm just putting his chair in here.
Thank you. Very much.
We'll be back.
Yeah, okay, thank you. Very much.
Okay. And I have also determined that you should be detained while you wait for your revocation hearing. Your revocation hearing will be scheduled upon the disposition of your pending criminal case. So once your case is resolved, you're going to be scheduled for another hearing. And at that time, a hearing examiner will determine if you violated the conditions of your parole. Okay? So once you'll come back again before us, once your current pending criminal charges are resolved.
You're gonna review them again and go over them?
Once your case is resolved, your criminal pending charges, yes, you'll come back and before us for another hearing.
And then you'll tell me whether it's resolved or it's not.
Well, the court, once your criminal pending charges are resolved, then you're going to come back for another hearing.
All right, let me understand this. I was supposed to go to court today and stand in front of a judge with my attorney. And that didn't happen.
Yeah, I don't know why that didn't happen, but once that your pending criminal charges are resolved, you'll come back before us at the board, and then we'll go from there in regards to what happens with at the revocation hearing.
Okay, now how will I know whether that part of the procedure is resolved?
You're going to go back to criminal court. You're going to get a disposition on your case. I don't know why you didn't go to criminal court today.
Yeah, I don't know why either.
Yeah, so so once that case is resolved, once we go back before the judge and get that resolved, you'll come back here again.
Why didn't we do that today like it was supposed to happen?
I have no idea. That's the criminal court. That's the superior court. Okay, so that does conclude this hearing. And again, so once those are resolved, you'll come back again.
Okay.
Okay, so this concludes your preliminary hearing. Go ahead.
Yeah, I have a question.
Yeah.
Between you and I.
This is a live streaming. This is live. I just want to let you know this is a live public hearing.
Okay, that's fine.
Okay.
But doesn't it sound logical that it was just a misunderstanding? Gum and gun?
Mr. Strano, I've made a finding of probable cause. I'm not. That's up to criminal court to determine the crime, the criminal part of that. Okay.
Okay, so they say I'm guilty. What do you say?
You have to have another hearing.
They do say I'm guilty. Am I screwed?
I can't answer that, Mr. Strano. You have to go through the whole revocation process. Okay.
We don't know how long that'll take.
We don't. It depends on how long it takes for your criminal case to be resolved.
Well, how do I know even know when my next criminal case, date is?
So contact your attorney.
I have to contact my attorney.
You should contact your attorney to know when your hearing is. So just, yeah, contact your attorney.
Well, it was supposed to be today, but that didn't work out.
Yeah,
Okay.
so.
Okay, okay.
All right, so thank you so much
Thank
and you're all set.
Thank you very much. Have a
No
nice
problem.
day.
You as
And
well.
thank
Thank you very
you.
much. Thank you.
Again.